Hello, everyone, and welcome to this webinar on data protection fundamentals by Poovayya and Company. A few of you are a little early. We'll just wait a minute or so, and then we'll slowly get started as more people trickle in. Once again, hello to everyone who's joining in for today's webinar on data protection fundamentals by Poovayya and Company. I'm Harini. I'm the partner of the data protection and AI practice at Poovayya and Company, and I will be leading this webinar today. I think we can slowly start easing into the webinar. I expect we'll still see some people trickling in at this point. We have a fair bit of ground to cover, so let's go ahead. First, a couple of housekeeping things. I'm using Mentimeter today to do this webinar because it makes the webinar much more interactive. I can share examples, ask questions, and audience members can respond to that. You can do that by either scanning this QR code or by going to menti.com and entering this code that's available here. Let me just drop it into the chat as well. You'll also see this on the question slides themselves. But for everyone who's joining in, welcome to the webinar on Data Protection Fundamentals by Poovayya and Company. This is Harini, partner of the Data Protection Practice. We are going to do this webinar in a concept-based way. And to do that, we'll have several examples, lots of questions, which I want the audience to respond to, all you attendees. So please either scan this QR code or go to menti.com and enter this code 58883134. Again, as we are waiting, I'm going to start off with a question for everyone who is attending, and it's going to be a very easy one to answer. For those of you who've been able to open Menti, if you have any issues in responding to this question, please let me know. Otherwise, please go right ahead and respond. And while we wait for people to join and respond, I'll just share again that what it is that we're going to do in this webinar. We will have a legal and non-legal audience here today, and so it's going to be highly concept-based. I'm going to help you understand the basics of data protection by taking you through some of the important terms and concepts, like what is personal data. We will also cover when does the DPDP Act apply and when does it not. We will look at important entities under the DPDP Act, like data fiduciaries, data principals, who's a data processor, and how to understand the relationship between a data fiduciary and a data processor. We will have pretty much examples for every one of these so that it's very practical and easy to follow along for those of you who are not so familiar with data protection. For those of you who've joined a little bit late, you can answer all the questions in this webinar by going to menti.com and using the code that you see there, 58883134. I've also shared this in the chat window. Once you do that, you'll be able to respond to all the questions. And all the responses are always displayed on in an aggregate form. So no particular person or responder is identified. So please feel free to answer freely. I think we should go ahead and move on. And if anybody joins later, hopefully they will raise a hand or type something in the chat box. Also, if you have any questions as we progress, please raise your hand or type your question into the chat box. To the extent possible, having an eye on the time, I will try to respond as and when. If that's not possible, we also will have time for a Q&A session at the end of the webinar. So you will be able to hold on to your question and ask me then. But where possible and where it's relevant to do so, I'll try to respond as we go along as well. So we're going to jump right into things, dive right into the heart of the matter. So when we talk about data protection, the main thing is that we are trying to protect personal data and the rights of people vis-a-vis their own personal data. So a lot of obligations and responsibilities that flow under enactments like the DPDP Act come into play only when you're processing personal data. So that's why it's very important to understand clearly what is personal data. Under the Act, personal data is any data about an individual who is identifiable by or in relation to such data. To break this down, there are two ways in which you could have personal data. One is personal data that directly identifies a person. Let's think of some examples here. A person's name, a person's facial image. So those are things that directly identify a person. So it is data about an individual who's identifiable by that data. But that's not all. A person can also be identified in relation to that data or identifiable in relation to such data. What's the difference here? So I'll give you an example. Let's say that you have a person's email address. Now, with a person's email address, you may or may not be able to directly identify exactly who that person is. So if you are a service to which that person has signed up and provided other data, for example, then by using that email address, you may be able to find linked pieces of data that will then help you identify them. So, or you may be able to do a Google search with a person's email address and then find their LinkedIn profile with their name and a photo of them and so on. So if you have data and a person becomes identifiable in relation to such data, then that data should be treated as personal data. I want to make one here, which is quite important, which is that you should always consider personal data as an interconnected web. What do I mean by that? It's very rarely that you will see personal data as a single data item or as a single data field. Most of the time, what we see is personal data will always be linked to other bits of data. Because of that, any one of those bits of data can actually help you identify a person. So if you think about the way in which businesses especially process data, they might have a person's name, email ID, phone number, date of birth. Now, if you were to have only that person's date of birth, you would probably not be able to identify them. But when you have all these other data items stored, then they become an interconnected web. By querying a date of birth and perhaps adding certain other filters to it, you will be able to exactly identify a particular person. And that's why it's not effective to think about personal data as one single piece of data. It's always better to think of personal data as an interconnected web with different data items. I am aware that this might still be a little bit abstract, so we're going to go ahead and jump into an example now. And at the end of this example, I'm going to also ask a question. So in our example, we have an e-commerce store called Ecom. Now, Ecom uses a logistics service provider called Logis to deliver goods to its customers who place orders on the site. Ecom only shares a user ID and a house address or delivery address for the customers to Logis. Now, Logis in turn engages Bikers, which is a bike delivery service provider, to make the last mile deliveries. And again, Logis only shares the user ID and address with Bikers. Whenever delivery updates need to be sent, Bikers sends these to Logis, which in turn sends it to Ecom. And Ecom is the one that has the phone number, the email address of the user, and so shares this information with them. So this is our example. There's one more point here, which is not completely relevant for this question, but when making deliveries, Bikers riders request recipients to sign up for the Bikers app and offer them a discount. if you'd like a little bit more time to just look at this example, I'll wait a few seconds and then we'll go over to the question. Meanwhile, if you have any other questions, if you've joined the webinar a little bit later, please note I'm using Mentimeter. So you can go to menti.com and type in 5888-3134 as the code. It's also in the chat window. And when you do that, you'll be able to respond to all the questions in the webinar. You can also note that responses are aggregated. So there's no response that's tied to a particular attendee in the webinar itself. So let's go over to our question screen now. Is the user ID in our example personal data? Now, this is a sliding scale assessment, so you can express your opinion in terms of strongly agree or strongly disagree. You can either do this by joining menti.com on your laptop or using your mobile device. And I'm waiting to see what kind of responses we get. So I also wanted to use this example to explain certain nuances in what it is that we're doing. I think at the moment, we don't have very many responses. I'm hoping to see if we get any more. Sorry. So I'm going to go ahead and go on with the explanation here. So should the user ID be treated as personal data or not? So when we looked at what is personal data, we were trying to understand it from the perspective of, is the data something that makes a person identifiable by itself or in relation, or is the person identifiable in relation to that data? So when you have just a user ID in the abstract, would you be able to identify a person? This also relates to another concept called pseudonymization. This is not exactly what is happening here, but pseudonymization is when you have data in relation to a person, personal data, and you scrub it or you strip it of certain identifying characteristics, and you segregate it in a way that just by having that data, you cannot identify a person. So what ecom seems to have been trying to do here is to do some kind of pseudonymization where they say, I don't need to share everything about my user. I don't need to share their name, their phone number, their email address. This is quite unlikely under the circumstances, but let's just see this as an example. I will only share what really needs to be shared to get the deliveries done. So in this context, you could argue actually that user ID may not be personal data in the hands of logists. In the hands of ecom, because it has all the other data in that interconnected web, then in all likelihood, it would be treated as personal data. But in the hands of bikers, again, they have only the user ID and the house address. However, when a person actually goes to make that delivery, in all probability, they're meeting a person who's the recipient. They may see a name board at that house address. So it's more likely that even the user ID could be treated as personal data in the hands of bikers. So the main point of this example is to show you that just by understanding what is a user ID or what is a particular piece of data, you can't necessarily make a determination whether or not it is personal data. Until you know what is that interconnected web, what are all the other pieces of data that link to this. When you do, then you might be able to make a better assessment as to whether something is personal data or not. So now we've understood what is personal data, and we can apply that to understand whether or not to apply the DPDP Act and comply with all the obligations under that when we are processing certain data. But there's also another step we need to consider, which is whether or not the DPDP Act itself applies. The DPDP Act applies to the processing of digital personal data, where the processing happens within India. It can also apply where processing happens outside of India, but where this is in connection with an activity related to offering goods and services to data principals who are within India. So that's quite a lot to break down. Essentially, if you have a situation where you're processing personal data and either the data principals are within India, you are processing the data within India, or the processing is outside India, but you're offering goods and services to data principals in India. Now, there's also the question of when does the DPDP Act not apply? The DPDP Act does not apply to personal data processing where it is for personal or domestic purposes. This one I can explain with an easy example. Let's say your grandmother calls you up one day and says she needs to travel somewhere and she wants you to book a train ticket for her. So you take her Aadhaar number and then you make a train ticket booking. Now, in this case, you have taken her Aadhaar number, you have her name, you have her date of birth, and you are processing it in digital form. But you're doing it for arguably a personal or domestic reason. So then the DPDP Act does not apply. So if you write that down or if you store it somewhere on your computer, you store a copy of her Aadhaar, this particular processing will not fall under the DPDP Act. On the other hand, if this were not your grandmother, but you were providing a travel service to somebody else, you're a travel agent, the DPDP Act would apply. There's another situation where the DPDP Act does not apply, which is quite interesting. It does not apply where personal data has been made public, either by the data principal, the person that the data relates to, or by someone who is under an obligation to make that data public. Again, we can understand this with a couple of examples. One is given in the Act where a blogger shares personal data about herself on her blog. Then she has made it public. So the DPDP Act does not apply if you use that personal data or to that particular situation. On the other hand, we have another situation, which is when you incorporate a company or set up an LLP or some such, you will share a bunch of personal data. You will fill it out in the application form, which was then stored by the MCA and actually made public. What happens then? If you have ever been through this process, you will know that you will be spammed with phone calls and emails, especially from banks, to offer you that they will set up your current account or your business account for your new business. How can they do this? Because your phone number and email address have been made public by the MCA, but under certain legal obligations that they are under. So in that case, you cannot say that they did not take my consent to call me, because at the moment, whether you would call this a lacuna or a loophole, this does exist. So that's how it happens. So I've explained a little bit about when the DPDP Act does not apply. I'd also like to explain about when it does, and we'll do that again with another example. So we have TICO, which is a company which is set up in Singapore. The company offers online Telugu language classes for children, and it allows people from anywhere in the world to register and set up accounts for their children usually. TICO also starts having tie-ups with some schools, and what the schools do is they collect information on paper forms, and they take consent from parents on paper forms, and then create accounts for them on the website of TICO. So we'll move to the question now. Does the DPDP Act apply to TICO here? Anybody interested in answering? If you recall the fact situation, TICO is a company in Singapore and it offers Telugu language classes online, and people have to set up accounts on the website to be able to access those classes, and it is meant for children. Please don't be shy to respond. Go to, I hope the instructions are still visible in case you joined a little bit late. You can go to menti.com and use the code 5888-3134, and then you can respond to questions. Also, if you have any other questions in the meanwhile, please feel free to drop them in the chat box. And where possible, I will address them on the go. If not, hold on to the thought, and at the end, we'll have a Q&A session. You know, I intentionally included it depends because there are quite a lot of lawyers who are attending the session today. Okay, so I'm going to go with yes here for several reasons. Now, I'll slightly contrast this to the approach in the EU. In the EU, there's also a piece on targeting people by providing services that are likely to appeal to them. Those are not the exact words, but something similar to that under the GDPR. But even in this case, what happens is that when you look at a language like Telugu, now predominantly it's going to be spoken in India. And TICO is going to be aware that its services are likely to be taken by people in India. And even if you've set up outside of India, if you're offering goods and services to people in India, and especially in this instance, let's say that schools are actually starting to enroll or to create accounts on TICO, then the DPDP Act would apply under these circumstances to TICO. This does not mean that other data protection laws do not apply to TICO. For instance, if TICO has people signing up from other jurisdictions as well, then arguably those jurisdictions' data protection laws apply as well. And then there's another question for you here. So we've established that the DPDP Act does apply to TICO under this case. Does it also apply to the account creation by the schools? So this is again a sliding scale question. So you can choose your response in terms of strongly agree or strongly disagree for each of these statements. So there's a little bit of a nugget here. I'm going to go ahead and reference something that I said earlier on the applicability of the DPDP Act, which is that the DPDP Act applies to the processing of digital personal data. What this means is that, or it explains further in the Act that if you're directly processing digital data, then the DPDP Act applies. It also applies if you take data in a non-digital form. So for example, paper forms, or you've written down something and subsequently digitize that data, then the DPDP Act applies. If we break down the steps here, now when the schools are actually doing the data collection, they're doing it on paper forms. So what they're doing is sending forms home with kids and asking parents to fill it out and sign up and give their consent and bring back those forms. So at that stage of data collection, the DPDP Act does not apply. But when they take it and do a data entry or create accounts for the children on TICO based on this consent, then at that stage, the DPDP Act does begin to apply. Now, if you were to ask me, then what happens at the stage of these paper forms to the data collection? That's actually not addressed by the DPDP Act. So it is literally the Digital Personal Data Protection Act. The assumption seems to be that it is digital data that can be manipulated a lot more in the course of processing, and so it needs a lot more protection. So we now move on to some important definitions and also entities that perform certain roles under the Act. Now, the first we've already touched upon briefly, who is a data principal. The data principal is the person to whom the personal data relates, also called a data subject in other laws. The next person that we need to be aware of is the data fiduciary. The data fiduciary is the entity, either alone or jointly with others, that determines the purpose and means of processing data. What do we understand from this? A data fiduciary, also known as a controller in other jurisdictions, is the entity that essentially sets up the entire data processing as a notion, or the reason why the data processing happens is because of the data fiduciary. They determine the purpose, meaning why is the personal data being processed, and the means, meaning how is the data going to be processed. So the entity that makes those decisions is the data fiduciary. Now, why do you have to understand who is the data fiduciary or controller? It is because in most laws, the entire responsibility or most of the responsibility for compliance with the data protection law falls on this controller or data fiduciary. And that's the same in India as well. If you are the one that is enabling the data processing, but you haven't decided or you are not the entity that decides why this data processing needs to happen or how, you may not be the data fiduciary, then the primary responsibility is not on you. Let's take an example again from ecom and lodges in a moment. We'll come and see the difference there. So one of the things that you can also think of in understanding this is if you're the entity that has set up an entire business, you've said, this is my business model where I will take this data from users and use it for that. That means you're the one who's decided why is this data being processed. And if you then decide, I'm going to do it myself, or I'm going to engage a processor, we'll come to that. I'm going to engage somebody else to do X or Y with this customer data for me, then you may be the data fiduciary. There's a separate class of data fiduciaries under the DPDP Act that we should all be aware of, and these are significant data fiduciaries. Now, significant data fiduciaries are to be notified by the central government. They have not yet been notified, but there's a number of factors that are mentioned under the Act which will be relevant in deciding who is a significant data fiduciary. So these include things like the volume and nature of data that is going to be processed, whether what kind of processing the significant data fiduciary does might have significant effects on the sovereignty and integrity of India, public order, or on electoral democracy, and so on. So the sense is that this data fiduciary is processing personal data of a certain volume, of a certain nature, or is conducting data processing operations that have significant implications for the country as a whole. Why do you need to understand this? It's because significant data fiduciaries have more obligations under the Act. This includes things like performing an annual data protection impact assessment and a data audit. Now, this data processing audit, the report that is generated, significant elements from that need to be submitted to the Data Protection Board of India as well on an annual basis. There are also implications on data localization, and significant data fiduciaries need to appoint a data processing officer or DPO, which other fiduciaries, it is optional for them, but for the significant data fiduciary, it is mandatory. We move on to the next category, which is a data processor. A data processor is an entity that processes personal data on behalf of a data fiduciary. So the business of that data processor might be to actually process personal data in a particular way, but they do so on the instructions and for a data fiduciary. I'll give you an example in relation to this, which is that if I'm using a certain cloud service, now the cloud service may be storing certain personal data like customer data that I upload there, but they are not doing this because they want to store the customer data. They are processing that personal data on my behalf. So I'm the data fiduciary and they are the data processor. We'll go back to our earlier example in a moment after we understand what do we mean by processing. Now, I've seen in many contexts in India that there's a tendency to use the word use in relation to data, to say that only if you use the data, it's significant. No, the word is processing. Similar to the GDPR, not identical, processing covers a wide range of operations, not just collection and use, but also structuring, combination, adaptation, if you do analytics on it, if you share it or disclose it, even if you delete it or erase it or restrict it. I like to joke to clients that if you've so much as looked at the personal data, it's almost radioactive, so it's immediately been processed. So the chances that what you're doing is not going to constitute processing are very slim. So any interaction that you have with personal data, you should err on the side of caution and assume that you are in fact processing it. Just take a moment again to look at our example. We had ecom, which was sharing a user ID and a home address or delivery address for customers with Lodges. Lodges was sharing these with bikers. Now, bikers was doing the final last mile delivery on behalf of ecom and Lodges, arguably. And what bikers also does is to go up to people who are receiving the deliveries and saying, hey, why don't you download my app and I'm going to give you a discount. So in this case, who are the data fiduciaries? Any answers? You can pick all the ones that apply. You can pick more than one. Waiting for more responses. Remember, this is aggregated, so you can feel free to pick anything that you like. I'm going to give it just another 30 seconds, so please hurry up and pick your responses. Okay, so I'm going to go ahead and start answering this now. Any last minute answers? No? Good job. All right, so in this case, we'll start at the beginning, right? So who set up an e-commerce store and is collecting customer personal data and allowing the sale of goods on their site? That's e-com. So e-com has decided that it wants to run an e-commerce store and sell goods to customers, and therefore it is collecting and processing their personal data. So e-com is a data fiduciary or a controller. It's decided the purposes of personal data processing, and it is also the one that has engaged Logis in order to do this processing. When I come to Logis, by and large, Logis has decided to offer its processing services to customers who need it, logistics as a logistics service provider. Now, if you look at whatever personal data Logis processes on behalf of e-com, and I mean only customer personal data, Logis is doing this when e-com tells it to. When e-com says, hey, here's some customer personal data, not in those words, of course. Here are these customers and these are the orders that they've made. Now you go out and make that happen. So Logis is actually processing that personal data, engaging a sub-processor, Bikers, in order to fulfill e-com's instructions. So in my view, Logis, to the extent it's only doing what we've discussed in the example, is a processor and not a data fiduciary. You can apply a similar logic to Bikers. Logis gives this data to Bikers and says, go out and make these deliveries happen. So to the extent Bikers is taking this data and going and doing the deliveries, up to that point, Bikers is just a processor or a sub-processor, as it's called. So you have a hierarchy of processors. The first processor engaged is called processor usually. But if they engage another processor, that person gets called a sub-processor. Mostly we try to avoid words like sub processor because in the modern business world, it gets very complex. So we just say processors and sub processors. So Bikers is a sub processor for ecom. But things get muddied when Bikers riders ask people to sign up for the Bikers app. At that point, what these people are doing is they use the house address and the fact that they're going there to make that delivery to pitch Bikers' own service, which is an app. So when you do that, Bikers is not simply processing the personal data on behalf of Logis and therefore on behalf of ecom. They're processing it on their own behalf. They've decided the purpose to get more customers for Bikers. And the means is by asking their bike riders to basically use any opportunity to ask people to download the app. So for that particular activity, Bikers is actually a data fiduciary. And this is something that everyone who is in a business should be aware of. Even if you are normally only a processor, the moment you step out of the bounds of the instructions given to you by the data fiduciary and you start processing the data for your own purpose, then you become a fiduciary for that purpose. And this is something very important to remember. So going a little bit deeper into the data processing relationship, this is something that's very important, and usually you will see it in a variety of cases. I know many of you may have looked at a data processing addendum or data processing agreement as well. These tend to be a lot more complex or specific in the EU. This is because Article 28 of the GDPR actually sets out a bunch of requirements for data processing agreements, and all data processing agreements need to have these. On the other hand, in India, the situation is quite different. Firstly, the data processor and data fiduciary relationship, there's very little mention of it. Secondly, it's very clearly stated in the Act and rules that it is the data fiduciary that is responsible for all compliance with the DPDP Act. So under the law, the duty to comply is not placed on the processor. If you've ever done GDPR work, especially in this context, you will know that there are also specific obligations on the processor under the GDPR. But in India, all the obligations are actually primarily on the fiduciary. And the third thing is that what do you need to actually set up this kind of a data processing relationship? You need a valid legal contract, and that's about it. One thing that data processors do need to keep in mind is that they need to comply with reasonable security safeguards. And these actually need to be mentioned in the contract. That's the only thing that, as of now, the Act and rules require in this data processing agreements in India. Everything else is left to contractual negotiation. That's both a good and a bad thing, depending if you're a data fiduciary or a data processor. But also, it depends then on the relative bargaining strength of the parties. Having said that, especially for data fiduciaries, but even for processors, it's always good to make certain things very clear. And I'll explain why. Some of the contractual safeguards you need to have are mentioning that the data processor will only process data on the fiduciary's instructions. You should also have a purpose limitation. If you're a fiduciary, that's very important. What is the purpose limitation? Where you say that the data processor is only going to process this data for the purposes that you have told them to process it. So in our earlier example, lodges should be telling bikers that you will only process this data to do this delivery and for nothing else. It will also be very helpful if you get the processor to agree to cooperate with the fiduciary for data subject rights. So for instance, if there is a complaint that is lodged with Ecom that, or if a data subject reaches out to Ecom to say, you need to delete my address from your database and from all of your processors. Now, it helps them to have that right in the contract with the processors. You might also want to address things like engagement of sub-processors. Again, Logis is actually Ecom's processor. Logis has engaged bikers. So you want the same obligations that are there in your contract with your processor to be trickled down into all contracts with sub-processors. By mentioning that clearly in the contract, it gets very helpful. And of course, you want to ensure that there's a certain level of confidentiality and that data security measures are considered as well. Another element to consider is international data flows. So you may not only be hiring a processor or sub-processor that is within India, you may also be engaging processors which are outside India. So you need to consider what happens in terms of different jurisdictions' data protection laws and where's the data going and what kind of safeguards do you need in that respect. So we'll go on to another example now. We have Appy, which is a mobile app. Sorry, I'm not very imaginative when it comes to some of these names. So users need to provide their email ID, name and mobile number, date of birth, and then they can sign up for the app. And users can cross-post content across different social media networks by syncing these social media network accounts to Appy. And Appy's databases are actually maintained in India normally, but Appy does use CRM Easy for customer data management. CRM Easy is headquartered in the EU and provides a cloud service. Appy also uses Cloudy for some cloud compute services, and Cloudy is based in the US. So before I move on to the question, let's just bear in mind there are a number of contractual safeguards that you should consider as a fiduciary. I also forgot to mention, of course, that even if you are the data processor, it helps you when you're engaging sub-processors or for you to have a clear boundary on your liability to the data fiduciary that you've mentioned clearly in the contract what you will and will not do, who will be responsible in certain situations. And by laying these kind of things down, it makes it easier for you as well. So now we have this in mind. Let's go to the question. What data protection issues would you advise Appy to consider here? And this is a slightly different kind of question, so you can write your responses here. And you can also vote on other people's responses. So let's take a few minutes to see how that goes. Remember, Appy is the one that's providing the service, which allows you to sync your social media accounts and cross-post. Appy has engaged CRM Easy in the EU and Cloudy API maintains its databases in India. So firstly, API is the data fiduciary here. CRM Easy and Cloudy are its processors. So what kind of data protection issues should API consider? Any answers? No answers at all? Am I not making sense? Sorry, I'm on mute. Those are pretty good ones. I'm going to go upward there. That's a good one too. Any others? So at the moment, it doesn't seem like data transfers outside India are, as a matter of fact, restricted, but there can be some restrictions. Any others? Okay. So I'm going to take a moment to go back to the slide with the example. So some of the things that API needs to do are, yes, purpose limitation. They need to ensure that when CRM Easy is processing this data, they only process it for the purposes of enabling CRM for API, that is customer relationship management for API. No marketing to be done or any other kind of use of customers' data by CRM Easy. API also needs to ensure that data security is maintained by CRM Easy and by Cloudy. API needs to consider things like, since this data is going outside of India to the EU or to the US, are there any specific restrictions that apply, assuming they come in? API should also consider having requirements around disclosure of sub-processors, for example. And this might be specifically important in the Indian context because we may see some restrictions on data transfers to specific countries. In that case, you should know where all your customers' data is going when you engage a processor, so they need to disclose the sub-processors to you. Some of this will also come down to bargaining power and how much you can mandate. There was recently some requirements in the EU around doing a much deeper level of due diligence on processors and sub-processors. So how far down can you go? There's also a risk-based assessment to be made there. So you can vote on the responses now, if you'd like to. Okay. I'm going to move on to the next slide, then we'll have some time for Q&A in case you'd like to ask any questions. Okay, we have 2 votes, 3 votes. Four votes. Okay, so maybe I should wait a little bit. Great. Okay, 30 more seconds, then I think we can wrap up and look at how the voting went. All right. The non-disclosure agreement bit is a little bit interesting. Whoever put this in, I think I would like to hear more from you in the Q&A time if you're willing to share. All right, let's move on. This is our last slide before we head to the Q&A because we had only an hour to begin with today. So I'm going to deal a little bit with the lawful basis for processing personal data. Now, whenever you're processing personal data under the DPDP Act, you need to have a lawful purpose, which is anything that is not prohibited by law. So, for example, to do marketing, to enable a user to enjoy certain features, you need to take this data from them, so on, and to help, say, users sign up to a particular account, then you need them to give this data. So those kind of purposes are all lawful purposes, as long as it's not prohibited by law. Then the next step is to understand whether you have a basis for processing the data. The primary basis for processing data under the DPDP Act is consent. All the other bases come secondary to that, and that's how it's actually laid out in the Act. When it comes to consent, the consent needs to be free, specific, informed. It needs to be provided by a clear affirmative action. What do we mean by that? You cannot have a checkbox which is already ticked and consider that as consent given by the user. That's not allowed. Instead, you ask a question and then they need to take an action to demonstrate that their answer is yes or that they consent. So these are all important elements. There's another very important element, which is that it is purpose limited. We've come across this a couple of times during this webinar now. Basically, if you tell someone, I want to process your personal data for X or Y reason, and they give the consent, then that consent is only valid for that X or Y reason. It is not valid for anything else. So if you say, for example, you ask a user, please share your phone number so that we can text you with updates about when goods will get delivered to you. Now, you should not, without independently taking consent, you cannot ask them, you cannot start sending them marketing communications. If they say, yes, you can send me this kind of communication. So it's clear that you have to limit it to the purpose for which you asked. If you say, give me your phone number so I can tell you when this goods will be delivered to you, you cannot then after that say, hey, I'm just going to share this other marketing communications with you 3 times a day. So that's one of the things that you should remember about consent. There are also other bases under the Act, including things like compliance with a judgment or where you might be required to provide certain data to a lawful authority. What is more likely to be useful to us in a certain context is that you can process personal data for employment purposes, including for situations like where you expect corporate espionage or where you want to protect your IP, your company's IP, and so on. So the employment purposes basis is slightly wide. I would recommend that you go and have a look at it a little bit later. There's another very interesting basis. Now, first, a couple of bases that are missing when you compare it to more international frameworks. One is, of course, legitimate interest, which is there under the GDPR, which is that you say as a business, you have a certain reason to process personal data. You have a legitimate interest in doing so. That comes with certain requirements. We will not go into those here. But here you don't have that. There's only consent and a few other bases that you can use. Another is contractual necessity, again, something that you see under the GDPR, which is that in order to perform this contract with the data principal or the data subject, I need to take these actions and process their personal data in this manner. That is available under the GDPR. It is not available here. So you cannot say, I need to process the personal data in order to provide this because that's what they've signed up for. It is a little bit restrictive, but it's not only that. So you do have something a little bit similar, but not quite. you have something called the voluntary provision of data basis, which is a sort of implied consent basis. What do we mean by that? Under the DPDP Act, you can apply this basis when someone gives you their data voluntarily for a specified purpose, and they've not told you that they don't consent to your using it. So it's quite a double negative there. Essentially, if a person gives their personal data voluntarily for a specific purpose and they don't withdraw consent for its use in that manner, then you can assume that they have actually consented. That's more or less the gist of this purpose. And I can give you an example for this. Say in a retail store, you're ringing up purchases by a person, and the cashier then asks that person, "Can I have your mobile number? We will send you the receipt on WhatsApp. We will also store your number in our customer loyalty program where we can send you details of offers." Now, if this person says, "Okay," and that's about it, then you can assume that they've provided their consent as well for their number to be stored and used for marketing and for the loyalty program. On the other hand, let's say this person says, "You can send me the receipt. I don't want to be on the loyalty program." Then there's no consent here under the voluntary provision of data basis. There's no voluntary provision of data for enrolling them in the loyalty program or sending them marketing communications. So it has to be linked to a specified purpose, and they should not have withdrawn their consent. And of course, they are voluntarily providing that data. Now, how that would look in a digital situation is something that you can think over. It fully understand that UI UX needs also exist. But for example, if it's not mandatory for a person to provide certain data, that is, it's not a starred field in a digital form, but it's up to them to provide or not provide that data, then in that case, it's more likely, in my view, that it would be considered as being voluntarily provided. So anyway, we are coming to the end of the session. I wanted to save some time for Q&A. So I will be stopping here. There's a lot more to cover, but I doubt we would anyway be able to finish all of it in one session. So what we've gone through today is that we've looked at some core concepts. We've looked at what is personal data. You should always know which of your data is personal data. And that's important because the DPDP Act only applies to processing of digital personal data. We've looked at who's a data fiduciary and who's a data principal and some lawful bases. You need to understand in any data processing situation, what is your role? Are you a data fiduciary? Are you a data processor? And what are the requirements that apply to you? We've also looked at when does the DPDP Act apply more generally. And of course, we've looked at the fiduciary processor relationship, again, in a slightly truncated manner, because there's a lot more that we could go into. We could go into specific formats of DPAs, compare it with the GDPR, etc. But today, this is the amount of time that we have on hand, and we've tried to cover a fair bit of ground. We are, of course, able to do a deeper dive on request. We are able to provide trainings and training sessions, workshops, tabletop exercises, and the like on various elements under the DPDP Act, such as consent management. We also do trainings on data inventory, data flow mapping, DPIs, DPAs, TIAs, transfer impact assessments for international transfers of data. We can, of course, provide trainings on these and also actually help you and assist you in carrying these out. And also, of course, understanding data processing agreements and data sharing agreements. Data sharing agreements are slightly different from data processing agreements. Normally, when they are controller to controller or fiduciary to fiduciary in the Indian context, you may have a data sharing agreement, which is a little bit more applicable than a data processing agreement. So we are able to assist on all these things and also provide detailed training sessions, workshops, and in-person activities, tabletop exercises, etc. on all of these. I would request everyone in this webinar to please fill out the feedback form. There's a QR code on the screen. Thank you so much for attending this webinar. I hope it was helpful. Please scan this feedback form QR code and share your feedback. It would be really helpful for us as well. And finally, if there's any questions, I'd be quite happy to take them at this point. You can either add your questions into the Menti, or you can raise your hand and ask questions, or you can type it into the chat box, whatever works. Also, if you would rather not ask the question here, but if you would rather ask the question offline, that's an option as well. I think at least some of you will have my email ID from the invite. If not, we also have it here. Please make note of the email ID if you would like to ask me any questions. Of course, yes, sure, I'll be happy to share the presentation. We'll also be putting up this webinar on YouTube, and I will be happy to share the link as well. Is having an NDA necessary along with DPA for every transaction? Um, they're very different beasts. So a non-disclosure agreement is typically something that you would sign in relation to specific information that should be kept in a certain confidential way because it is particularly important, or it has a certain, like, say, trade secret kind of value. It's proprietary information. For a data processing agreement, it depends. You could just fold some of those provisions in. For example, some data processing agreements might require that you share detailed information on what technical organizational security measures that you take. In that case, for instance, the other side might want that you sign an NDA or include such confidentiality provisions, because if those measures get out, for one thing, their data security gets significantly impacted as well. So you may not need a standalone NDA. You could possibly fold it into the document, but it really depends on further context. Even if the consent is not withdrawn. Yes, so I didn't have the time to cover this, but essentially under the Indian DPDP Act, one of the features that you see is that you do need to have very robust notice to your data subject to the data principal, whether or not you're relying on consent. And in this notice, privacy notice, which could be a privacy policy to some extent, you need to explain what personal data are you collecting, for what purpose, and also a sort of indication on the retention as well. And there are also rules, at least in the draft rules, that you should only retain data for as long as necessary to fulfill the purpose. And in certain cases, for certain kinds of fiduciaries, you need to actually delete that data after a period of time, assuming the data principal has not interacted with you, has not used your platform for whatever is the purpose for which they would normally use the platform, etc. So you do need to give notice. And in relation to consent specifically, you need to give notice of exactly what consent you're taking, why, what is the purpose for which you're taking that consent, and there's other information to be provided. So you need to have a combination of a privacy policy and a just-in-time notice. You're welcome. So how can a data fiduciary limit its obligation in form of capping of liability? The data fiduciary actually, I would say, cannot really cap its liability, because the data fiduciary's liability will be decided by what kind of penalty is imposed on the data fiduciary. But the data fiduciary can try contractually to cascade down that liability to its data processor to the extent that the liability is incurred due to the data processor's actions, or of course, depending on your bargaining power. So what is the point of defending capping your liability? Again, it's hard for a data fiduciary to defend capping its liability, because its liability is going to arise usually not from the data processor, because the data flow goes from the data fiduciary to the processor, not so much from the processor to the fiduciary. Whatever personal data the processor is sharing with the fiduciary typically originates from the fiduciary or is related to the personal data that the fiduciary had in the first place. So it's hard for the fiduciary to cap liability. We're almost out of time. Any other questions? Happy to wait for a minute or two more, or even longer, if anyone has any other questions. Otherwise, we always have the option. I've shared my email ID. You can go ahead and also send me any other questions that you may have. Is direct marketing using data of a website user still possible? Um, Again, you should analyze firstly whether this is personal data. Also, where are you getting this data from? Um, for the specified purpose requirement, if you're using cookies, almost all websites nowadays have a cookie notice and a consent form. You also have consent management options on tools like Google Ads. I don't readily recall how they do it on Meta, but even if you're installing a Google tag on your website, for example, you can activate consent mode on Google Tag Manager, and then it will respect the consent notification from the user. But it really depends. Um, so if you're using, for instance, a person's IP address, um, I think we should probably have an offline discussion on this. I'd want a little bit more context because my mind is branching off into different scenarios. So I think it's not going to be something I can answer right away. Um, Welcome. All right. I think seems like there's no other questions. Thank you so much for attending, and have a great day.